Hopefully you can all hear me. We're going to be doing what we call an estate planning webinar here this morning, and thank you so much for joining us. My name is David Wingate. And then, obviously we're all becoming experts in Zoom. That I didn't even know what Zoom was, but I don't know about you, but if we have family Zooms, everybody's talking at once and nobody can get in. So when we've done a few of these, so what we're doing is just muting everybody. Now I'll wait to the end to take some questions about this, but if you actually have some questions, you can actually go into the the chat room, and then you can send a question. You can send it to Kristen or everybody, and then as you go, or you can write down the questions, and and then we'll answer the questions as we go, if that's okay with everybody. Then I'm just going to start right at this moment in time. Okay. So the big question is, why are you here? Are you worried about yourself, your spouse, children, grandchildren? Do you have problems with some siblings? Are we going to leave monies to siblings, other beneficiaries? Or are we concerned about your mother or father? Also, why are we here? Is it because we want to protect our hard-earned, assets, or do we have a family business? Are we wanting to protect our monies during our life? And what's going to happen after your death? Are you going to leave everything to the federal government, the state of Maryland, with death taxes, etc.? And we're going to be discussing all of this here today. Additionally, the problem is, if we pass away, we want to make distributions to our beneficiaries. But what happens if you're leaving some money to your grandchildren and they're 12, or you have a child with autistic problems, or spendthrift problems, or problems with drugs, alcohol? And, so obviously we want to have some clarity, and we'll try and, clarify everything today. Most of the time, once we're completed, the big thing is giving you peace of mind, because you've got all your ducks in a row. So protection, clarity, and peace of mind start with legal documents. So what types of legal documents are we going to talk about here today? We're going to be talking about power of attorneys. There's two types of power of attorneys that we're going to talk about. One's, financial, healthcare, and living wills. And then we're also going to talk about, your last will and testament, and some trusts. So that's what we're going to be talking about here today. And obviously, not everything has to go through a will or a trust. Sometimes we have beneficiary designations, especially with IRAs, one life insurance. But most importantly, we have to have a plan. And that's what we're talking about today. We'll wrap that up. What happens if you don't have a plan, and what happens if you have a plan? So, to me, what is the most important estate planning document? The most important estate planning document is a power of attorney, because we're dealing with you while you are still alive, rather than dealing with your last will and testament, where we're dealing with you once you're gone from this world. So what is a power of attorney? It's basically a written document where one person, principal, let's say me, authorizes another person, an agent, to act on my behalf. So for me, I have a power of attorney. I'm the principal, and I've appointed my wife, the agent, to act on my behalf if I get sick. So she can basically then step in my shoes to take care of me financially and medically. Why is that important? Because even though we're married, or have a partner, or a child, or a family member, technically they have no authority to act on your behalf, okay? So even though that I am married, my wife can't make some financial decisions for me, especially if I have IRAs, a house, 401ks, and technically she can't even make medical decisions for me. So if I'm sick, I've got dementia, or I'm in a coma or whatever, then she can't make decisions. And so we've got to go through to the courthouse, and we've got to go through a guardianship proceeding. And we want to avoid that at all costs. Why is that? Because it's a very costly expense. Hiring attorneys, most guardianships are well over $10,000. They're also ongoing. Every year you have to report to the court, with a financial report. Sometimes if you have to make medical decisions, you've got to get authorization from the court. I don't know about you, but I don't want to have to go in front of someone with a black robe who doesn't know me. I want to have someone that I know, love, and trust to make decisions for me. And the other thing is, the guardianship usually takes 3 months. So what happens if I'm in a nursing home and the nursing home's costing $12,000, $15,000 a month? That could be $35,000, $40,000, $50,000. And that's needlessly if we have these power of attorneys. So if we have the power of attorneys, we don't need a guardianship. So that's why it's very important to have these power of attorneys. So as I say, there's 2 types of power of attorney. One's the financial and one is the healthcare. So I'm sorry, I hit it twice. So, sorry, I'm very clumsy today. There we go. So, as I say, what is the financial power of attorney? Most financial power of attorneys authorize the agent to open and close bank accounts, sell real estate, defend you in litigation, deal with insurance. Basically, the easiest way to think about a financial power of attorney, as I said earlier, is anything that I can do, my financial power of attorney can do. So, as I say, they can act on my behalf when I'm incapacitated. However, not all financial power of attorneys, are equal, because some financial power of attorneys do not have certain clauses or paragraphs in them that we need, especially if we're trying to protect your assets from the nursing home. Basically, one of the most important clauses, or 2 most important clauses, are making what we call gifts and making unlimited gifts. So if you do not have a power of attorney, a financial power of attorney, you need to have one. The other one is, if you do have a financial power of attorney, we're going to talk about it. You need to review it to make sure it's up to date and make sure you have this clause of having what we call unlimited gifts. And that allows us to protect your assets if you're going into a nursing home. The other thing with a financial power of attorney is that you can set up trusts, especially irrevocable trusts. And we're going to come back and talk about the irrevocable trust. But an irrevocable trust is a way to protect your money from the nursing home. Because as we'll find out, the average cost of the nursing home is about $15,000. The average length of stay in a nursing home is about 50 months. You're talking $750,000 for one person. For most of my clients, we can't afford that. So that's why you're probably on the call here today. And also, we can set up special needs trusts and dealing with digital assets, especially the way things are doing, that people are on Facebook or Zoom and, online banking as well. So we need to review your power of attorneys to make sure we have all these clauses. So, as I said, anything I can do, my financial power of attorney can do, and likewise with the healthcare power of attorney. So I can authorize my agent, i.e. I authorize my wife, my spouse, to make medical decisions for me. You can consent to surgery or, not consent to the surgery, withdraw it. Admit to or discharge to a hospital or a nursing home. They can review medical records. There's, a thing called, I think everybody's getting familiar with the word called HIPAA, is the Privacy Act. And so if I went to your physician and said, let me see your medical records, the physician should tell me no, because you haven't given me a HIPAA release. So we've built our HIPAA release into our healthcare power of attorney. And likewise, that your agent then can talk to your physician or healthcare professionals, because otherwise, technically, they can't talk to you because it's a violation of HIPAA. Also, part of our healthcare power of attorney, we have included in it, and there's really three sections to it. One is the appointment of the healthcare agent to make your healthcare decisions. The second component is the HIPAA release. And the third one is what we call, the living will, or if you see it called an advance directive or a medical directive, all three things is basically the same. However, most people know it as a living will. So what is the living will? Basically, it's written healthcare instructions regarding your end of life. So what happens if I'm in a vegetative state, a terminal condition? Do I want to be hooked up to machines, or should you just let me go? Okay. So for most people, they're saying, if I'm in an end stage condition, vegetative state, just let me go, but provide me comfort care. And what do you mean by that? Well, is that give me pain relieving drugs? Well, what happens? Do I need any artificial hydration? Or artificial nutrition? These are types of things that we can talk about and make decisions for you, because do you want to, or do you want to prolong your life, and wait till the year 2160 for the cure of the common cold or whatever we're going to do. So these are the types of components that we have. So as I said right at the beginning, these are the most important documents that you can have, is a financial power of attorney and a medical power of attorney. So what are the components of your financial power of attorney? Because who's going to be, and your medical power of attorney, who's going to be your agent? Is it going to be your spouse? But what happens if your spouse is sick? And then do you want to make them your power of attorney? So maybe you're going to go to your children. Some people say, well, I've got to use my oldest child. Well, you don't have to use your oldest child. You want to use the most responsible child. Like the other one, it'd be for a medical power of attorney. Our recommendation is, obviously if the child's responsible, then, use a local child, because if your child stays in Japan and they're trying to make medical decisions for you, it's kind of hard. But if someone's in, Frederick, Rockville, Hagerstown, or, even West Virginia or Pennsylvania, that's the local child, we recommend them. Do you want to recommend all children to be your agent? As we'll see, I don't recommend that. We're usually, because we don't want to run by committee, you're better just having one child, okay? And you can utilize the same person for financial and healthcare, or you can use different people. So let's say you have one child who is a nurse or a doctor or whatever, maybe you want to use them for medical. And then you have one who is a financial advisor or an accountant or whatever, you might want to use them, for the financial ones. So it just depends. Everybody's different, okay? So who should be your agent? Obviously, it's someone who you trust. They've got to be responsible and they've got to be skilled. And what I mean by that is, well, you don't want a child to be your financial power of attorney if they're constantly filing for bankruptcy or in foreclosure. You want someone who knows what they're doing. So as I said, is if you don't have a power of attorney, you need to get them. If you do have them, you need to review them. Now, years ago, Maryland updated the power of attorneys. So you got to make sure that your power of attorneys are in compliance with the law, that you and your agent are still on the same wavelength, to achieve your goals, and verify that you have named successor agents. What do I mean by that? So let's say I have appointed my wife and nobody else. Well, God forbid that we're in a car accident or something like this and both of us get sick or injured, then I don't have anybody who can make decisions for me because she's in the next hospital bed with me, okay? So you want to make sure that there's other people. So it could be your siblings, it could be, your children, it could be an aunt, uncle, or whoever, okay? And you want to make sure that they still want to be your agent, because we've had people coming in saying, hey, this part, I'm a power of attorney and I never wanted to be the power of attorney. They never asked me and I want to resign. Or maybe you've made this power of attorney 10, 20 years ago or whatever, even 5 years ago. And now the power of attorney is sick with dementia or, old age or something like this, and they don't want to do it. So my recommendation is review your power of attorneys every 2 to 3 years, or if there's been a major incident, divorce, breakup, etc. I'm not saying you have to change them every 2 to 3 years, but at least you're reviewing them, okay? So that's your power of attorneys. As I said, again, the two most important documents that you can have. Now, when you die, your power of attorneys die with you. And that's when we move into last wills and trusts. So we're going to talk about the last will and testament right now, and we're going to talk about trusts in a couple of minutes, okay? So what is a last will and testament? Basically, it's written instructions on how your property is going to be distributed upon your death. So for me, for most people, we call what we call I love you wills. So if I die, I have a will that says I'm leaving everything to my spouse. If my spouse predeceases me, then it's going to go to the children. And, I might have some provisions in there for some charities or to look after the dog. So that's basically, what a last will and testament is. Also, you designate what we call a personal representative. We used to call them executors, administrators. And this is going to be the person who administers your estate. So if you think about the estate as a little business, then your personal representative is the manager of the business, because that manager wants to make sure that your wishes are followed through. Now, going through your last will and testament, it forces you to go through probate. Now, probate is the process that usually takes well over a year to administer your estate and make the distribution to your named beneficiaries, because you have to go through all this dog and pony show of doing inventories, accountings, and getting approval by the court, etc. And that usually takes over a year, and then the distribution can be made. Now, obviously, if you have also minor children, and if both the husband and wife, the parents die, you can designate a guardian for your minor child. So if I have a child who's, 12, 8, or 17, they're not going to be, and I still want someone to look after them. So I'm going to designate a guardian for them until they're 18. So that's what you can sort of, do with your last will and testament. As I said, that most people have what we call I love you wills. If I die, it's going to go to my spouse. If my spouse predeceases me, it goes to the children. Now, as we get older, sometimes we want to maybe revise our will to I love you, but. I love you, but. Because what do I mean by this? So let's say, that my wife is in the nursing home, okay? And she's on Medicaid, where Medicaid is paying for her care. And I have a house and some monies or whatever. Now, if I died before her and I have I love you will, that means all of my possessions are now going to go to her. Now, that means that she's going to have assets over $2,500, and that means then she'll be getting kicked off of Medicaid, because Medicaid is not going to pay for her if she has more than $2,500. Now, all of a sudden, she's got my checking, savings, and the house. So what I want to do is say, I love you, but. So what I'm going to do is, I love you, my wife. However, I'm only going to give you a certain amount of my estate, basically what we call a spousal share, a spousal election. So she, let's say, gets 20%. So let's say my estate is $100,000. She gets 20% of my estate. She gets $20,000. And the remaining 80%, 80,000, is kept in a trust for her benefit. Now, the nursing home can't get at that 80%. So it's very important, because then that money is there for her benefit for whatever Medicaid doesn't pay for. Because when you're on Medicaid, you basically get an allowance of roughly $72. Now, you can't even afford basic cable for $72. So we want to try and keep this money for her benefit, but not give it over to the nursing home. So that's why sometimes we want to change it to your last will and testament, I love you, but. So what are some will substitutes rather than going through probate? Well, obviously we're going to talk about trust in a minute, but basically there's sometimes, what we call beneficiary designations. So if I have an annuity, a life insurance, an IRA, I normally have to name beneficiaries. So if I have a life insurance, I'm going to name my spouse, the beneficiary. So when I die, she will get as the beneficiary my life insurance or my IRA, and it doesn't have to go through probate. Now, once again, if she was in the nursing home, we want to change those beneficiaries from me. If I die with my life insurance, I don't want it going to my wife, because then if she's on Medicaid, then she's going to lose her Medicaid. So we might want to name the children. Same thing with the IRA. There's other will substitutes called transfer on death. Sometimes it's payable on death. If you hear POD, TOD, each bank or financial institution has their own names, okay? And once again, that is basically like a beneficiary. So if I have a checking account that is just in my name, and I name my wife, payable on death to her or a child or whatever, then that money would go directly to that beneficiary. It wouldn't have to go through probate. And likewise with real estate. For most of us, we have joint tenancy. That means our home is owned by husband and wife. So what happens if I die? Then my wife takes over. And likewise, if she passes, because it's joint, the survivor takes over. Sometimes we have a tenancy in common. This is unusual, but sometimes we have this. So what that means is, if I have it with my wife, there's husband and wife, and we're tenancy in common, that means I own half of the house, and she owns half of the house. So when I die, I can give half of my house to whoever I want to give to. And likewise, she can as well. Sometimes that can get complicated, especially when you have, what we call blended families, okay? So our tendency is to use joint tenancy. So as we say, we've got to have what we call comprehensive estate planning, because if we don't plan, we can be in a muddle. So what are we planning for? Maybe some short-term disability. What happens if I fall and break my hip and I end up going into a nursing home for rehab, and then I'm going to come back, okay? So what happens if I'm out of it? And that's where we're talking about the power of attorneys. Are we going to be talking about, planning for long-term care? What happens if I go into a nursing home? Am I going to lose all of my assets, and who's going to take care of me? And then also, obviously, we're planning for what happens when we move on from this world. Who is going to get my assets, and when are they going to get my assets? Some people say, well, what I want to do is just give everything to my children. I'm going to put my kid's name on the deed. I'm going to make them joint owners. I don't like that, because we call it the 4 Ds. So what happens if your kids get divorced? Let's say you like your daughter-in-law or son-in-law right at this moment in time, but if they get divorced, maybe you won't like them because they might be coming after some of your property. What happens if your children get forced into bankruptcy or foreclosure, lose their jobs, and then they're getting sued? So then if your child is on your property, then these creditors can put liens against your house, and if you have to sell that house, then the creditors will take that money. What happens if your child ends up disabled or even going into the nursing home? Or what happens if they die? Then what's going to happen to your properties? So for us, from my point of view, we don't like giving stuff to children, because as I say, especially if it's an outright transfer, not even a joint, but let's say I take $100,000 and give it to my son, and then he dies and he has a will and he gives that $100,000 to my daughter-in-law. As I say, I like my daughter-in-law right at this moment in time, but if she gets my $100,000, I don't know if I'll like her as much. So we don't like outright transfers to children. We would rather put it into a trust that we still have control over. And that sort of leads us into an introduction to trusts. Most people say, well, I don't have much, too much money. I don't have enough money. What is a trust? So what I'm going to do is try and explain some trusts. So there's various types of trusts. And it just depends, what's a good fit for you. For my clientele, we're utilizing like 3 types of trust. And that's what we're going to be talking about later on. One's called a revocable trust, one's an irrevocable trust, and one's what we call a supplemental or special needs trust. And basically that is for your children or grandchildren with special needs. So it just depends on, what you're in the market for. Are you in the market for a sports car, SUV, truck, or van? So that's just the type of trust it is. Do you want a big fancy schmancy thing, or do you just want the paper vanilla ones? Okay? Because understanding the framework of the trust, if we keep it in the car, so exploring the types of trust is the vehicle. Do we want the Lamborghini, or do we want a Honda Accord or an SUV? Because it's based upon your objectives. It might be that you have, 22 million or $50 million. Well, you're going to be concerned about estate tax. I would say all of my clients don't have to worry about federal estate tax or even Maryland estate tax, okay? The death tax. Because if you're a married couple, the federal government is not going to be interested in you unless you have more than $22 million, okay? If you've got $22 million or above, I won't help you because I don't know about all these offshore stuff. So you'd have to go and talk to someone else. Also, the type of trust is based on your beneficiary circumstances that we talked about, and we will talk about, setting up special needs trusts or revocable or irrevocable trusts for your children or your grandchildren. Now, so what are the assets? Assets are like the gasoline. The car can't drive without fuel, without gas. And it's the same thing with the trust. The trust really can't do anything unless it's funded. And we fund it with financial assets and or, your home or homes. And also, even if the car, you've got the gasoline, it's not going to go anywhere unless you have the driver. And the driver is the trustee, and that's the person who manages the trust. So if you think about the trust, you've got the owner of the trust, you've got the manager of the trust, and also you've got the beneficiary of the trust, and that's you or your children or whatever. So what are some common objectives for establishing trusts? One of the big things that a lot of our clients want to do is avoid probate. And probate was the process that you take your will, your death certificate down to the register of wills. They're going to open up an estate. Then you go through the probate of inventories, accountings. You're appointing the personal representative. It usually, as I say, takes about a year before the distribution. There's court costs, attorney's costs, personal representative costs. So sometimes, that we don't want to do that. And so we can avoid probate by doing what we call a revocable trust, and we're going to talk about that next. Also, another objective of establishing a trust is for long-term care protection. So that's where we're going to be talking about protecting your assets from the nursing home or your long-term care costs. And the way that we do that is through an irrevocable trust that we'll talk about in a couple of minutes. Sometimes we have to control the gifting. So we've got a trust. And unfortunately, sometimes some of our clients have problems with their children because of drugs, alcohol, opioids, or a spendthrift. And if you were to turn over and just give them $100,000, it would disappear. They would run off to Vegas or whatever. So sometimes, what we want to do is have the trust hold on to the money when we're gone, and then they give the beneficiary, give Johnny $50 a week for the rest of his life or until that money, disappears. Or what happens if you were going to give some money to a grandchild, and the grandchild's 5 years old? Are they going to be good with money or indifferent with money? We just don't know at the moment. So you might say, well, I'm going to keep that money in the trust until that, that child is now 25. Or I might give that child half at 25 and half at 35. So they don't get that money when they're 18 and blow it. Sometimes, we're establishing trust to reduce federal estate tax. Obviously, we're talking about a beneficiary, his supplemental needs. And basically, the most common objective is managing your assets upon death. How are we going to get that money out quickly? Or are we going to hold on to that money because we're worried about our children or grandchildren or whatever? So, as I mentioned, the types of trust that we have in this office traditionally are what we call go back. I hit the button too fast. Revocable, irrevocable, and special needs. Now, there are a whole bunch of the other types of trusts called charitable remainder trusts, irrevocable life insurance trusts, estate tax trusts, those type of things. But we're not really getting involved in those today because we don't really handle those. These are the three types of trust that we handle in this office. So, what is the revocable trust? Well, revocable means it's the ability to amend or revoke. So with a revocable trust, you have the ability to amend or revoke the trust. So once again, if we think about, the trust is a little business, you're the owner of the business, so you can change the business, revoke it, modify it. You're also with a revocable trust, you're basically the owner, and you're also the manager. We call you the trustee. The trustee manages the trust. So you manage your own trust, and you're also the beneficiary of the trust while you're still alive. Now, when you die, then you're not the trustee, but we have successor alternate trustees that would step into your position, okay? So let's say that me and my wife are the trustees. We're also the owners of the trust. So when we die, obviously we can't be the owners anymore. Well, we are still the owners, but we can't revoke it because only we could revoke it. So it becomes an irrevocable trust. That means nobody can change it. And also we have successor trustees to manage the trust. Now, their job is to get everything out of the trust to the beneficiaries, or if there's certain provisions in that trust that we hold on to the money to give to our children or grandchildren because of special needs, because of problems with drugs or alcohol, or spendthrifts, or whatever, then they continue to run that trust, manage that trust until the trust meets its goals, okay? So the whole idea of this revocable trust is to avoid probate. The reason why that is because when you die, although you own the trust, the trust owns all of your assets. So your house, your checking, your savings, all of those are in your trust. So when you die, you don't own anything except for the trust. So there's nothing to probate. You have nothing titled solely in your name. Like if I had a house and it was just in my name, I have a checking account, a savings account, money market account, just in my name, those assets would have to go through probate and be distributed by my will. And they would get tied up for a year or whatever in costs. But because I have a revocable trust and all of my assets, the checking, savings, and the house are in the revocable trust, I don't own anything outside of the trust, so there's nothing to probate, and then the trust then can distribute the assets, or as I say, hold on to them. Now, the revocable trust does not, let me stress, does not protect your assets from the nursing home. I can't tell you how many people come into my office and say, well, I've got a trust, it's a revocable trust, my assets are protected from the nursing home. That is not the case. The only thing that a revocable trust does is avoid probate. It does not, stress, does not protect your assets from the nursing home. Because with a revocable trust, you're in control. You can reach into that trust and grab the assets. If you can reach in and grab the assets, so can the nursing home. So that's where we do what we call an irrevocable trust. The irrevocable trust can protect your assets from the nursing home. The big difference between the irrevocable trust and the revocable trust. Once again, I'm the owner of the irrevocable trust. I set it up. You know, it's, once again, it's just like the will or the revocable trust. Who is going to get my assets when I die? Okay? However, the big difference between the revocable trust and the irrevocable trust is the irrevocable trust, I'm not the trustee and I'm not the beneficiary. So once I put something in there, I lose control. It goes into the irrevocable trust and I can't reach in there and grab it. If I can't reach in there and grab it, neither can the nursing home. So that's how we protect your assets from the nursing home. The other caveat is that whenever you put something into that irrevocable trust, you have to get through 5 years. That's, you know, we'll talk about this in the 5-year look back. So if you go into a nursing home, you're going to apply for Medicaid. Medicaid people look back 5 years to see what you've done with your monies, if you've gifted your monies or not, okay? Because if you've gifted monies away, then that causes problems with Medicaid, that you're disqualified depending on how much you've given away. But if we do this irrevocable trust more than 5 years ago, whatever you put into that, you know, into the irrevocable trust, for a lot of our clients, we're putting in, you know, just even the house or maybe some monies, okay? We get through the 5 years, then that house is protected for your spouse or your children or your grandchildren. So that's why we use these two types of trust, the revocable and the irrevocable. Also, we do what we call supplemental needs trust or special needs trust. So this is if you have a, you know, a special needs child, a grandchild. So a lot of people, like through a revocable trust or a will, say, well, I want to leave $50,000 to my grandchild who has special needs. The problem with doing that is if you give that child the $50,000, they can lose their government benefits. They could lose their Medicaid, their health, etc., because now you've given them $50,000, because they can only get these government programs if they've got less than $2,000. So how we get around that is that you set up a special needs trust, or sometimes we call it a supplemental needs trust, that you take your $50,000 and put it into this trust for their benefit. So they can, that grandchild or child can get at it, but you can use through a trustee to get that money out to them, and they don't lose their government benefits. So they continue their government benefits to take care of them, but they've also got this special needs trust that you can use monies to pay for, vacations, special beds, special wheelchairs, etc. So to me, these are the three types of trust that we utilize. So as you can see, we need a comprehensive plan. You must plan, because what happens if I do not plan, or I did not plan, and I'm going from A to B, and God forbid there's a detour. The detour is that, I think I'm going to be, a long, happy life, but now the detour is that I've got to go to a nursing home. Well, you might be planning to give all your children or grandchildren a whole bunch of money, but that money may be depleted because it all goes to the nursing home. What happens if you just have a will, or even if you don't have a will? The state of Maryland has a will for you. You might not like it, so you want to plan. What happens if I get sick? What happens if I get dementia? What happens if I get Parkinson's? Or, what happens if I'm a coma? Do I have someone in place to take care of me, to take care of my assets? Can I protect anything? Maybe if you don't, you might not be able to protect anything because you go to the nursing home. I can't tell you how many people go to the nursing home and they lose everything. It used to be that we didn't have to worry about really nursing homes because we worked over 65, we retired, and most of us back in the 50s, 60s, and 70s, we died at 70, 70 and a half or whatever. But now people are living well into their 80s, 90s, and 100s. So what happens if you lose all your money? What happens? I'm 99, I've got no money left, and I'm starting to get sick. What happens if my spouse is going to get sick? Am I going to be able to live? What's going to happen to me? So that's why, we talked about you must plan. What's the estate planning? What's your income? What's your retirement plan? Because if you plan, then you've got, some contingencies. So thank you so much for listening to me. I know I've rambled on for, like 40 minutes, but they always say with these Zooms that you shouldn't go more than 40 minutes. So thank you so much for allowing me to talk to you today. What I'm going to do is, stay on here. And if there's anybody who has any questions, I don't know, Kristen, if there was any questions in the chat line, or if you want to open up for people to talk here today. Ask me any questions, okay? And once again, thank you so much for listening to me today. If we can help you in any way, please contact the office. What we're doing is, as I say, we're recording this, and we might even send it to you, if and then you can review this as well. Okay. As again, thanks very much.
Okay, I have a question.
Yes.
You talked about Medicare and the Medicaid and the nursing homes.
Yes.
What if you have long-term care insurance? How does that
play? Yes. Okay. That's a very good question. I'm sorry, there's only so much that I can talk about. Probably, maybe in a few weeks, that I'm going to have a specific seminar just dealing with Medicaid and the nursing homes. So we'll reach out to you, because today we're just talking about estate planning side.
Okay, yeah. Then I have a second question.
Yeah, let me answer your first question. I'm sorry.
Oh, okay. I thought you were saying you weren't going to do it today.
Oh, no, I apologize. But I was just giving you some information. So if you have long-term care insurance is great, okay? Because, if you get sick, the government is not going to pay you in any monies whatsoever unless you're in the nursing home, okay?
Right.
So if I am sick and I don't need nursing home, but I need help at home, then the long-term care can pay for that, depending on your policy.
Right.
Because depending on what your allowance is per day and when it kicks in. So let's say that you have a long-term care policy says the policy will kick in after you can't do 2 activities of daily living, bathing, dressing, eating, going to the bathroom, and it's $100 a day. Well, $100 a day is roughly $3,000. That might be good for a few hours at home, but it will not pay for the nursing home, because the nursing home is $15,000 a month. So if you're paying privately, let's say you get $100 a day, that's $3,000. The nursing home cost is 12. So 12 minus 3,000 is 9,000. You've still to come up with the $9,000 until you qualify for Medicaid. So.
Okay. Well, some of them you have a pre-qualification period, and some of them will only do in-home, or some of them will only do in the nursing home. But yes. I guess I was wondering if you talked about Medicaid. I'm not at all familiar with it, and I mean I've heard of it, but do nursing homes traditionally take you if all you have is Medicaid?
Yes, actually, most people in the nursing homes would probably say, I'm estimating 80% of people in nursing homes are on Medicaid, because most people, you know, they don't have, you know, if you know, $15,000 a month times 50 months is $750,000.
No, that's true.
Yeah, most people don't have $750,000 to pay for, you know, 4 or 5 years of nursing home.
Or if they did, they may have lost it.
Right.
From experience.
Yes. Yes.
Okay, in your original will thing, I think it was in the original will, I wrote down the words unlimited. And what was the unlimited part?
That was to do with your financial power of attorney, okay? Mm-hmm. And that was to deal with gifting.
With what was it?
Gifting.
Oh, gifting.
Gifts. Right. So some of the strategies that we need to protect your assets from the nursing home, that means that your agent has to have the ability to make gifts, to take money out of your assets, to, we don't like the word hide from the nursing home. We like the word relocate, okay? So we want to be able, and we have to have that gifting clause in there that allows your agent to reallocate that money.
Okay. I'm going to have to review my, I already have a will and a power of attorney, but I'm going to have to review them. Can I ask you another question?
Yes, absolutely.
Where's your accent from?
Originally from Scotland.
Oh, me too. Burns clan.
Oh, really? Okay. Well, my father just passed away last year, but my mother lives in Dumfries, where Robert Burns died.
Oh, well, I haven't
died of boredom, I think.
Boredom. And of course, I'm a big time Outlander fan too.
Ah, right. My wife is. I've never watched it.
Oh, you should. You should. Yeah. It's good.
That's why I left the country. I don't want to have to see it.
Oh, well, a lot of it takes place in the United States. They come here.
Oh, yeah, I know. Yeah, I realized that they come.
I'm sorry. I didn't mean to get you off, but I kept wondering, what is that accent? I've never been to Scotland, but
well, when I go to Scotland, I'm a damn Yankee to them. I have no Scottish accent whatsoever.
And I think Graham is also Scottish. Yeah.
It's a Scottish name, yeah.
Those are both. So, okay. Well, and okay, well, I'm going to review some things. I'm going to look over some of the stuff. This is this was very interesting to me. So I don't want to take up all your time. So I'll shut up.
You're fine. Well, thank you so much for listening and asking some questions. Thank you.
I do have a question also.
Yes.
About if you own your house, you don't have a spouse, can the nursing home take your house?
Yes. Yes.
So how do you?
I'm sorry.
How do you avoid that from happening?
Well, my great legal answer is it depends. It depends when you're going into the nursing home. So let's say that, you know, that we're in our late 60s or 70s or early 80s and we're healthy. A lot of times what we're doing is we're taking that home and we're putting it into what we call the irrevocable trust. Okay, you can still live in that house. However, if that trust, when you put the house into that trust and it's more than 5 years when you go into the nursing home, that house is then protected. So that's what we're talking about, pre-crisis planning. When we're talking about our Medicaid planning, it's pre-crisis planning, coming up with a comprehensive plan to try and protect your assets from the nursing home. Now, if you end up going into the nursing home, God forbid, say tomorrow, then we're not going to be able to get through the 5 years probably. So there's ways, and that's where we're talking about those power of attorneys with the gifting clause. There's ways to try and protect, if you're a single person, at least 50, maybe 60% of those assets. Because if you don't, and you go into the nursing home with a house, they can't force you to sell the house. But what they're going to do is put liens against that. So let's say that you have a home and it's worth $300,000. You're in the nursing home, you go through your money, and then you go on Medicaid. So, and let's say Medicaid pays $400,000 towards your care. Medicaid will put a $400,000 lien against your $300,000 home. And then when you die, Medicaid takes your home. Okay, so that's why we want to set up, irrevocable trust to move your house into the trust. Or if you're going into the nursing home, there is still ways to try and save about 50, 60%, or depends on, of your home.
May I ask you one more question on that?
Yeah, absolutely. Yeah.
We had all that stuff and then we lost it. But I'm thinking about perhaps trying to buy another house, and I will turn 79 the 1st of December. And but if you were to set up this irrevocable trust before you bought a house and then put it in it, would the timing of it be the time that you set the irrevocable trust or the time that the house went into it?
It's whenever the house goes into the trust.
Okay.
So let's say that you put something into the trust today. Here we are, 2020. So come the end of 2025, it would be protected. If you set the trust up today and you put the house in, say, 2022, that house will be protected until 2027. Yeah.
Okay. Now I was just curious about what you were saying to her.
Yeah. Yeah. Was that Sue that, had the
Yes.
original question?
Yes.
Did I answer your question, Sue?
Yes. Will we automatically be invited to your next seminar? Because I
believe so. Yeah.
Okay.
Yeah. And usually if we've got your email, then we'll send it out to you. Yeah.
Okay. Because I do have questions about the whole Medicaid situation.
Yeah. We'll be doing a Medicaid, specifically about Medicare and Medicaid, 5% on Medicare, 95% on Medicaid, and how to protect your assets. I would say in the beginning of December.
Okay, great. Thank you so much.
You're very, very
This
welcome.
was very, very helpful and interesting.
Right. Okay. Any other questions?
No?
No.
Look forward to next time.
Okay. Thank you so much, everybody.
Thank you.
Oh, I don't know what happened there. Take care.
Thank you.
Bye.
3112112703003.
Well, that was interesting.